Why don't we get started on our next panel? So this panel, for the next little over an hour and a half or so, we're going to be speaking about what perhaps could have been more artfully called than it is, but other legal issues, non-environmental issues, but other, yeah, they are. Other than environmental, what else is there, right? Coming from an environmentalist. So we're going to be having a really great group of speakers speaking on this panel on a variety of different issues that are related but different. First, we're going to have Matt Liebman speaking on animal welfare issues. And Matt is senior attorney at the Animal Legal Defense Fund. We're really excited to have him here to speak from that perspective. Following him will be Dan Farber, who will be speaking about liability issues. Many of you may know who Dan is. Dan is the Shosato Professor of Law at the Berkeley Law School and writes on a variety of constitutional and environmental law issues. And we're excited to have him here to speak about liability issues, but broadly construed, to maybe even touch on other issues as well. And then he'll be followed by Jake Cherkow, who is also one of the co-hosts for this event. He's at Stanford, a fellow at the Center for Law and the Biosciences. Yes. I want to make sure I got all the prepositions right. And he will be speaking about property issues, primarily focusing on intellectual property questions, but also looking at property broadly construed as well. So starting off will be Matt on animal welfare. So please join me in welcoming.
Thanks, Alex. And thank you all for coming here. It's a little interesting to be on this side of the room. I went to law school here and had, I think, criminal procedure and constitutional law in this room. So from this perspective, it looks a little different.
Commerce clause.
No, I can ask you questions. So I'm going to be talking about the animal welfare implications of de-extinction research from both an ethical and a legal perspective. And what I want to do is start off by talking about some of the ways in which animals are used and the ways in which they suffer in the course of de-extinction research, and then talk about the various ethical frameworks that might answer the question of whether or not that suffering is justifiable or morally defensible. I'll leave the hard work to the later panel, but I do want to introduce some of the issues that come out of the animal rights philosophy. And then I'm going to finally conclude by talking a little bit about some of the legal implications of de-extinction research from an animal welfare perspective as well. So let's start off with somatic cell nuclear transfer, cloning. Thank you very much, Beth, for covering this, so I don't have to. She had a very similar slide. And I think that animal welfare issues arise before the clones come into existence. It begins with the harvesting of eggs from the donor on the upper left. And that's a process that involves some degree of intervention. It's not negligible in terms of risk and pain. It's certainly not the worst thing we do to animals, but I think it is something that has to factor into the moral calculus. Animals are typically induced into hyperovulation in order to harvest a large amount of eggs, and those are taken out in a somewhat invasive process. The next welfare issue that arises is the welfare of the surrogate. So once the cloned embryo is implanted into a surrogate, a new set of welfare implications arise. And obviously, conscripting anyone for pregnancy is not to be taken lightly. I say that as a new father who watched my partner go through 9 months of pregnancy and 36 hours of labor and delivery. So I think that is something that is morally relevant. Now, there's also a high rate of complications with cloned pregnancies in particular, high rate of late-term miscarriage and even death in some cases. These examples don't come from de-extinction for the most part because there haven't been that many data points, but there is much more extensive cloning when it comes to farmed animals, and a lot of the data comes from studies on cloning in dairy cows. And those studies have found a much higher rate of pregnancy problems with surrogates. And of course, if the animals aren't domestic, there's the inherent stress of captivity, as Beth mentioned with the example of the Bucardo domestic hybrid that went through extensive stress in the implantation process. But I think the issue that causes the most social anxiety and the one that's of most interest to a lot of people is the welfare of the clone herself. And I think a good example of these concerns comes out of that great cultural touchstone of my generation, The Simpsons, one of the Treehouse of Horrors episodes, which are the Halloween specials that are sort of a fantastical bent. And in this episode, a spoof of Harry Potter, and Bart and Lisa go off to wizard school, and they're learning how to turn toads into princes. And Lisa, being the straight-A student that she is, casts the spell perfectly, creates this archetypal British blue blood handsome prince. And of course, Bart, being the underachiever that he is, ends up creating this horrifying, pathetic little creature who simply wants to die and can do nothing but vomit on himself. Now, I'm not saying this is the stage of de-extinction research. Obviously an exaggeration to make a point. But there are welfare concerns that arise for animals, and some of the animals that have been cloned certainly live every moment in agony. I think an example of that is the bucardo, who lived for 10 or 12 minutes before dying, and the entirety of her existence outside of the womb was in intense respiratory distress. This is the problem. It's a supplementary non-functional lung lobe that has developed. That's the large mass in the bottom left that obstructed her breathing. And so, I think the welfare issues there are obvious. Another example is Noah, the baby gaur, and of course these were not extinct, but they are being cloned to help solve their endangerment. Noah lived for a couple of days before also succumbing. So these results that were found in endangered animals and the extincted animals also show up in cows. This graph reflects the difference in immune system issues, overall mortality, and other issues that prevent health and welfare issues for the cloned animals as well. And this isn't just the radical animal rights perspective. The European Food Safety Authority Scientific Committee also agreed that there were welfare concerns for both the surrogate and the clones themselves in this kind of research. And they were looking at whether or not to allow cloned food to enter the European food supply. These issues also, I think, show up to some extent in the genetic engineering method and what Beth called genome editing. And obviously, anytime you're tinkering with DNA and then producing animals, it's something of a roll of the dice to see what the outcome is. This is a slide from George Church's TED Talk that shows the genetic modification of mice to induce the growth of tusks. And I think that was probably relatively unpleasant for the mouse as well. But these are issues that I think go to the Bart end of the spectrum, that is producing animals who seem something amiss, that they're unnatural or something like that. Let's pretend that we're producing replicas at the Lisa end of the spectrum, that we have precise replicas. The question, again, arises, as other people have identified it, of where to put them. One of the suggestions is to put them in the zoo. This is one of Robert Lanza's slides from his TED Talk, where he proposes putting mammoths in a zoo. And I think the welfare implications of captivity generally have to be considered. This is something that the animal welfare movement has raised a lot of attention about. Elephants in particular have a special difficulty reproducing in captivity, and their welfare needs in captivity are very, very difficult, if not impossible, to meet in the zoo setting. In fact, we filed a lawsuit against the city of Seattle over the condition in which their zoo elephants lived. And I think these welfare concerns are not only things like the substrate, the space that they have, there are also issues of sociality, of culture, and the fact that animals have cognitive and psychological powers that we haven't quite appreciated yet, and keeping them in captivity with only one or two others of their species, or in some cases none, raises serious animal welfare problems that don't just have to do with pain and suffering, but also have to do with something a little more psychologically advanced. Another suggestion, other than keeping them in captivity, is to release them into the wild, and I think the conservation biologists will address some of the issues around that. It's also been suggested that they could be reintroduced for hunting purposes, which raises a host of other animal welfare concerns as well. And certainly introducing an animal into an environment for which she's not adapted, either because of the conditions conditions have changed since she lived in that environment, or because she doesn't have the sociality and the culture that plays a large role in adaptive behavior, that those animals suffer as a result. Now, just because an animal suffers doesn't mean it's per se immoral. I think the ethical framework that one adopts for resolving these questions in large part determines whether or not that suffering is going to be morally justifiable. So these are the three dominant ways of looking at our ethical obligations to animals. I think the most interesting work in animal ethics is being done outside of this triad, but these are certainly the most common ones. So let's take a look at those. At the top, we have the sort of strong animal rights position, which is a deontological idea that animals, either by virtue of their sentience or by virtue of being what Tom Reagan calls subjects of a life, they have rights that are inalienable, that can't be violated for the good of either human beings or for the good of any other species. This is an individual rights paradigm. And I think under that framework, it's really difficult to justify de-extinction research from the point of view of the surrogate whose body is commandeered to grow another animal, to the tinkering at the genomic level, arguably violates the animal's rights of biological integrity. I think the utilitarianism perspective is a little more forgiving. Under that view, it's certainly permissible to use others if the ultimate benefit outweighs the ultimate harms. And so if it were the case that either the joy that humans got from looking at extinct species or their joy in doing basic scientific research or the benefit to the animals in their future existence, if that's all on balance more pleasure than it causes pain, then it would be justified. But that's something of an empirical question that we could debate. And then there's the traditional welfarist perspective, which essentially holds that humans may do whatever they wish to animals so long as suffering is minimized. So as long as the end is one that's defensible, whether it's cosmetics testing, eating animals, using them for entertainment, those ends are all permissible, and our only obligation to them is to minimize suffering in the course of doing that. And under that framework, I think it's easy to justify de-extinction research on the grounds that we have a right to basic scientific knowledge and we have a right to using animals for entertainment or for wonder or whatever you want to call it. And as a result of that, so long as we don't cause them intentional suffering through the course of it, so long as the kind of suffering that I've discussed now is something that's not really the kind of gratuitous intentional suffering that the welfarist position, the traditional welfarist position, would reject. So I think which of these one adopts is going to affect how one sees the suffering of animals. So I want to talk, just in the few remaining minutes I have, about the legal framework from an animal welfare perspective. There are currently no laws that regulate de-extinction either at the state or federal level from an animal welfare perspective. Certainly there are laws regulating stem cell research and cloning and genetic engineering, but those tend to be from either an environmental or an anthropocentric perspective and not from an animal welfare perspective. So at the state level, I think the primary legal consideration are the anti-cruelty statutes, which prohibit unjustifiable animal suffering, although many, if not most of them, include exemptions for biomedical research. So I think the odds of, there's also political pressure against criminally prosecuting researchers, obviously. And so I don't think it's likely that we'll see criminal prosecution of de-extinction researchers, but I think this is a backdrop against which the research has to be considered. And then at the federal level, we have the Animal Welfare Act, which governs both animal research and the exhibition of animals in places like zoos. It establishes basic husbandry standards, things like space, food and water, cage size. And then for research facilities in particular, it requires the creation of institutional animal care and use committees, which must approve all animal research at that facility. They're required to look at whether or not the researcher has adequately considered non-animal alternatives and whether or not the researcher has reduced suffering to the maximum extent compatible with the research. And so I think that is probably the dominant legal regime governing this kind of research. But there's a couple of really interesting threshold questions. The first is whether or not de-extincted species are animals under the Animal Welfare Act. You'll note that cold-blooded animals, so the gastric brooding frog, birds such as the passenger pigeon, and mice such as those that are often used in the genetic engineering research, are not covered by the Animal Welfare Act. Certainly, Congress could amend the Act to define animal to include all animals used in de-extinction research if it chose to do so. There's also what's called the Public Health Service Policy, which extends a measure of protection to these species that are excluded under the Animal Welfare Act, but that law only applies where the research is federally funded. And Jake and Hank have argued, I think persuasively, that this kind of research should probably not be federally funded, that it's not worthy, that's not the issue, but that tax dollars shouldn't go to this and it should be privately supported. So in those cases, that research would not be subject to the Public Health Service Policy either. And of course, the most interesting issue, I think, is whether or not, if we ever got to the stage of cloning Neanderthals, whether that would be an animal under the Animal Welfare Act. And then finally, there's the question of whether or not this de-extinction practice is in fact research at all that's covered by the Act. And so APHIS, which is the Animal Plant Health Inspection Service of the USDA, has issued a policy statement saying that facilities that produce novel genetically engineered animals are using animals in research, so they are, so long as the animals are covered by the Act, subject to the requirements to minimize pain, the IACUC oversight, and things like that. But facilities that are producing cloned animals for regulated purposes, utilizing standard veterinary medical practices, are considered breeding and only have to be licensed as dealers with a lot less oversight and regulation. And so it might be one option for Congress, or at least the agency, to change its interpretation of whether or not the SCNT practice counts as research that would require oversight by IACUCs and all the attendant protections of the Animal Welfare Act. So that's the issues I wanted to raise. There's plenty more to discuss, and feel free to raise them in the questions if I haven't addressed an animal welfare issue that you're curious about. There's my email address, also happy to correspond offline. So thank you very much.
Okay, great. As you'll see, in tech terms, I'm somewhere between the group of people who didn't use PowerPoint at all and the people who have cool pictures and cartoons and stuff. This is going to be pretty bare bones, but I think it is kind of helpful, especially if you're not interested, if you're not familiar with the sort of legal background of this, just to be able to see some of the language. Let's see. So here are some of the, I was talking to Hank. He asked me to look at liability issues, and that seemed so open-ended. I wanted to get some examples of what kinds of things people might be worried about. So here are some of them. I'm sure they don't exhaust the universe at all, but say wandering herds of mammoths, eat your crops or tear up your trees or knock down your fences. You total your car against a woolly mammoth, or maybe we should say neo-mammoth because of what we learned earlier today about the science, and you break your arm. Passenger pigeons turn out to be a great vector for a disease that decimates domestic chicken flocks, or let's say even worse, for avian flu. or a de-extincted revived species takes over and ruins an ecosystem or hunting area, or something else, like kudzu in the south, rabbits in Australia. Who knows what passenger pigeons might do? They were a pretty major presence in the ecology when they were at their peak. And naturally, of course, the first thing you do is sue everybody you can find associated with the species, and in particular, whoever developed or released the animals. So the question is, what's going to happen when you go to court? I want to begin with some caveats. The caveats may take longer than the substance of the talk, actually. So when we talk about biology, biology is the same everywhere, right? You know, the same rules about RNA, DNA, et cetera, are in effect. Law isn't like that. Law is local. And in the case of tort law, local means state level. So each one of the 50 states has its own flavor of tort law. They're all pretty similar, with the exception of Louisiana, whose law is based on the French Napoleonic Code for historical reasons. But putting aside Louisiana, there are general similarities between all the systems, but they all have their own unique twists. Another thing I should tell you is that tort law is what we call common law, meaning that it's based on decisions of courts. It's not based on laws passed by legislatures, with a few exceptions here and there. But the basic legal structure is based on legal precedents developed by courts, and that means that it's not all written down in one place as one set of rules. You have to kind of try to reconstruct from the cases what you think the rules are and what you think courts will do in the future. So I'm not going to talk about cases from 50 states, and I'm not even going to talk about all the different perspectives that people have had about tort law. For simplicity, I'm going to pick one somewhat authoritative, that is, it's a source that people often look to for guidance, called the Restatement of Torts Third. There's also, obviously, a first and second restatement. The third one is relatively new. The second restatement was pretty widely followed by state courts. If you're interested, I can tell you more about where these things come from, but I won't right now. Third is new. We don't know for sure if it'll be followed. One of the reasons I want to use it is that it's simpler. I also think on the whole that it makes more sense, but your results may vary, as they say in the ads. Another thing is that facts matter a lot in tort law. I teach first-year torts class, and one of the main things that we try to teach the students is that you may have a rule that looks perfectly simple until the rule confronts a set of facts, and suddenly you're really in doubt about how to apply the rule, right? So facts matter a lot, and nuances of facts matter too. It's not just the general overall fact pattern. And I'm only going to talk about some of the issues. I'm not, for example, going to talk about nuisance law, which could be a consideration. I'm not going to talk about products liability law, which I think probably is not going to be an issue, but there could be an argument. I want to keep this relatively focused, partly because I want to make sure that this, or at least attempt to make this understandable even to people who are from other disciplines and don't know the first thing about tort law. And then finally, following up on one of the caveats given earlier, this is just academic speculation. This is not legal advice. So talk to your lawyer. Don't rely on what I'm telling you. Okay, so with all those caveats in mind, what does the liability situation look like? I'm going to focus on two major issues. There would certainly be other issues in any actual case, but the two I want to focus on are the ones that I think are conceptually the most important. One is the standard of liability. Will defendants be subject to a negligence rule, meaning that they're liable only if they fail to exercise reasonable care? Or will they be subject to strict liability, which means that they're liable even if they took all reasonable precautions, but something went wrong anyway, right? That's the basic distinction. And so one question is, what kind of liability are we going to see? Are we going to see strict or negligence liability? And the other is, what kinds of harms are you responsible for? You might think that if you are subject to strict liability or if you were negligent, that you would be responsible for anything that happens as a result of what you do, but the law doesn't actually work that way. You remember the children's rhyme about for want of a, where for want of a nail the horseshoe is lost, and then the horse is lost, and then it goes up to the kingdom is lost. Well, the blacksmith is not liable for the loss of the kingdom. We cut off liability in various ways, partly to prevent it from being so extraordinary and crushing that it seems unfair. So one question is, how might that operate in this setting? So let me begin with this question of negligence versus strict liability. I should also say that I'm going to be pretty descriptive here. If I were giving a talk for just a legal academic audience alone, I would be spending a lot more time talking about what I think would be the better answer and why, and I'm not going to really do very much of that in terms of policy, but I'll be happy to do that in the Q&A. Okay, so one rule that could be relevant, at least some situations, is strict liability for wild animals. And so the Restatement Third, which is pretty similar to the other restatements on this, says, an owner or possessor of a wild animal is subject to strict liability for physical harm caused by the animal. And then the comment makes it clear that the concern is with the wildness of the animal, that unlike domesticated animals, wild animals are apt to be more destructive, more difficult to control, and I think perhaps there's some sense that they may also have, that there may be less social benefit associated with them than there is with domesticated animals. So what does this mean? I think it's pretty simple. If you have a Bengal tiger, maybe you're a zoo, maybe, I'm not sure why you'd have one, but it gets out, it eats my pony. You're liable even if you carefully guarded the tiger. Even if the tiger got out through a fairly freak accident that you might not have been able to foresee. And the same result follows if it's a saber-toothed tiger, right? The fact that it's de-extincted really doesn't matter here. It's just the ordinary rules for wild animals. Similarly, your elephant gets out and causes damage. This is actually an example in the restatement, is the escaped elephant. You're going to be liable for the damage to property, and same thing if it's a woolly mammoth, right? So, in other words, what matters here is just that the animal isn't domesticated. And by the way, domesticated means locally used as a domestic animal in the US. So even though elephants are used as domesticated animals in some parts of the world, they're wild animals in the US context. And de-extinction really just doesn't change anything here, right? So if you have a project with woolly mammoths, be careful about letting them get out. Now what about the de-extinction itself? Is that subject to strict liability? The test is whether the activity is A, abnormally dangerous, right? So abnormally dangerous activities are subject to strict liability. Abnormally dangerous is based on two things. One is abnormal, the other is dangerous, right? So the dangerous part is a foreseeable risk of highly significant harm even when precautions are taken. And part two, it has to be not part of common usage. So de-extinction is not an activity of common usage, that's pretty clear, but does it create foreseeable and highly significant risks of physical harm? Not at all clear to me. I think I wouldn't say it's necessarily true as a general matter, and you'd have to know more about what the species is, et cetera, to think about whether there is that kind of risk. The second restatement test has 6 factors, and one of them is the social utility of the activity. So you may also want to be thinking about, why are we doing this? Is this, if there is some risk, is it a risk that we can justify taking based on whatever benefits I'm not sure being cool is going to be enough, although maybe it will be. The default standard is negligence. Negligence means you have to exercise reasonable care, which is kind of, sort of, a cost-benefit analysis of precautions. And the test is, the touchstone is foreseeability. What dangers can you foresee, and what would be reasonable precautions against those dangers? So in terms of liability, it seems to me there are some common risks with wild animals. They're going to apply. De-extinction, I think in most cases, should not be viewed as abnormally dangerous, but it's hard to be sure. And there's also a hindsight element. If somebody tries de-extinction, it looks safe beforehand, but it causes huge problems afterwards. There may be a hindsight bias leading people to think that that should have been foreseeable all along. In any event, you want to take reasonable precautions. So let me move quickly to proximate cause. Here's a case involving strict liability. Blasting operations frightened a mother mink owned by the plaintiff and caused her to kill her kittens. There is strict liability for all harms due to blasting. That's one of the classic examples of strict liability. Nevertheless, the court said that the defendant wasn't liable in this case. This wasn't the kind of risk that makes blasting dangerous. It was outside of the scope of that risk. And this is a difficult area. It drives law students crazy, drives lawyers crazy. But the restatement basically it uses a kind of similar test. Is this the kind of risk that made us decide that the activity was either negligent or abnormally dangerous? So putting all that together, it's hard to make firm predictions because these tests are somewhat vague, but foreseeability one way or another is likely to be the touchstone. The defendant may be strictly liable or not strictly liable, but either way, we're going to be talking about foreseeable risks. In other words, there should not be liability for unknown unknowns, things that we just couldn't have foreseen that turn out to be problems after the fact. So here's an example with passenger pigeons. Maybe they caused some kind of problem that we didn't even, maybe mammoths turn out to be, I don't know, for some bizarre reason they get avian flu and transmit it to people. Nobody could have anticipated that. That would be an example of a risk that I think clearly would not be or should not be subject to liability because it's not related to the known risks or foreseeable risks relating to the de-extinction. So I guess the bottom line is that although de-extinction is an extraordinary idea, it doesn't pose extraordinary tort risks. It poses normal risks, right? Now you can be liable for anything under some circumstance or another. If you have a miniature golf course, you can conceive of situations where somebody could hurt and the owner of the miniature golf course would be liable. If you have GMOs, if you are introducing species in new areas, all of those things are potential bases for liability, and all of the arguments that might come up with GMOs or an introduced species, or cloning, for example, could come up here. But the fact that it's de-extinction by itself doesn't seem like it's going to throw us into a category of extraordinary liability. Liability should be limited to foreseeable kinds of harms and risks, whether it's strict or not strict, rather than sort of black swan events that could not have been foreseen in advance. Now, I should probably put up my slide about caveats again at this point just to remind you of all of them, but at least based on what I can see now, that's sort of my best take on what the liability picture looks like. I think it should be reasonably reassuring. That is, it's not that there are no risks, but the risks are of kinds that people are used to confronting in other contexts, and that just have to be worked through in the particular context of a de-extinction effort. Thanks.
So just so I'm clear, is this on? Yes, okay. Hi there, my name is Jake Shirk. I'm a fellow here at the Center for Law and the Biosciences. Thank you all for coming today. I'm going to be talking about intellectual property and de-extinction. So I actually think that it's probably important to begin with first principles here, and that is, why do we have intellectual property or IP to begin with? So the traditional IP problem focuses on two things, that is research costs and the effect of copying. So if we come up with a new invention, if we write a new book, or if we engage in a very costly research and development program, how can we recoup those costs if someone could just come along and copy exactly what we did? And if that's true, who's going to go through the laborious process of writing a novel, or for that matter, engaging in pharmaceutical research, if once you make the first product and spend $100 million in the case of a drug, only to have someone in the next fell swoop come and copy it for 10 cents? And so in economic terms, we can describe this as there being a decreasing long-run average cost after our initial research. So we could think about this in terms of Dolly the sheep. Here is Dolly, and I guess, I don't know what the name of Dolly's cloned parent was, but there you go. So according to Forbes, the research program at the Roslin Institute, it cost about 1.7 million pounds back in 1996 to engage in all of the work to bring Dolly to fruition. And today, you can get a clone of various livestock for between $20,000 and $50,000, and there are a number of commercial services that will actually do this for you. And if we think about this in the de-extinction context, the current estimates there are also pretty high. A recent New York Times article links the Mammoth Project to be about $10 million. I don't think anyone's done an accounting for the passenger pigeon project, but I think that the cost estimates run just shy into the millions. And so and that's an important non-rhetorical if, we want to protect that investment, we're likely going to have to turn to intellectual property. So let me briefly speak to the if not. So if the goal of our de-extinction work is simply pure research, that is, we want the glory of being the first person to bring something back, or if we want widespread adoption, that is, not only do we not care, but we want people to copy us as many times and as quickly as possible, then I'd like to suggest that IP is in fact pretty pointless. Openness and transparency will likely speed the adoption much more so than anything else. But let me march through a couple of instances where the goals of de-extinction are likely more commercial in nature, and therefore the investment used to bring back species may be seen typically as something that inventors would want to recoup. So first, just like pure research, there's something called commercial follow-on research. That is, researchers may want to protect the methods that they use in creating the extinct species, either to sell to other researchers or simply to monetize more generally. So this is, in fact, what happened with Dolly the sheep. So no one got a patent for Dolly herself, but the researchers there at the Roslin Institute did, in fact, get patents on the methods they used to clone Dolly, as well as the stem cells, the lines of stem cells that they used to create various aspects of Dolly the sheep. And those, in fact, were the subject of several lawsuits here in the United States because they were so valuable. The other option is entertainment. So we may want to bring species back because we want to put them in zoos. Well, zoos are a business too. Zoos are part of a $13 billion a year business here in the United States, if you can believe that. And unlike museums, they derive the vast majority of their revenue from attendance. So with respect to that, as in the wild, competition is pretty fierce, and self-promotion is often the difference between life and death. So if we want to bring back the saber-toothed tiger, for example, and put them in zoos, those zoos may want to seriously think about ways to protect their exclusivity to the saber-toothed tiger. The other option is food. And so passenger pigeons went extinct because we hunted them not just for sport, but also for food. During the turn of the century, there were a number of pigeon wagons that traveled around the country doing various things, including selling pigeons for food. Various accounts at the times actually suggest that passenger pigeons were wonderfully delicious. They feasted mostly on chestnuts, and this was supposed to give them almost an Iberian ham-style flavor, which I think is kind of interesting. If you think this is far-fetched, if you think it's crazy that someone's going to bring a species back just so they can eat it, well, let me make a couple of points there. Number one, you don't take the foodie movement as seriously as I do, and I can tell you right now that I know a couple of people myself who'd be willing to pay top dollar to eat something that doesn't currently exist on the face of the earth. Number two, and I put this slide up only partially in jest, this is a slide from the movie The Freshman starring Matthew Broderick, where the mafia concocts this scheme to have a fancy diners club pay to eat a piece of the Komodo dragon, which is an endangered species. They actually end up doing a bait and switch. They get served healthy choice turkey, and no one is the wiser. But this anecdote that this movie is based from is actually from a real story. So in 1951, the Explorers Club, which was a bunch of relatively wealthy people in New York City who wanted to do things like travel around the world and taste exotic foods, at their annual dinner served woolly mammoth that they had defrosted from a glacier from the Aleutian Islands. And this is recorded in the historical meeting minutes of the Explorers Club. Whether that is in fact true itself or not, I'm not entirely sure. In other words, whether or not someone did another bait and switch for the Explorers Club, I cannot tell you. But this is stuff that happens. This is stuff that to a certain extent happens today. If you eat bluefin tuna, or if you have had bluefin tuna, you are eating a species that by many accounts is considered endangered. And people certainly pay top dollar to eat some of this fish. Another potential use would just be outright commercial products. That is, we want to sell revived species as pets. The exotic pet business here in the United States does about $2 billion a year, and these figures include black market numbers, and does about $20 billion worldwide. There are certainly people who would love to have a saber-toothed tiger at home, as crazy as that may sound. The last possible issue is that we may want to use them for ecosystem restoration purposes. So Pleistocene Park in Siberia, one of their goals is to bring back the mammoth, not just to bring back the mammoth, but to bring back the ecosystem there as well. They're going to need actual animals to do this. They may be willing to pay for it. So assuming that we do want some exclusive protection, what are the avenues that we're going to have? Well, so there's two broad forms of intellectual property I'm going to talk about. I'm going to talk about classical IP as well as some non-traditional avenues. So with respect to classical intellectual property, these generally come in three forms. There's copyrights, there's trademarks, there's patents. I'm not really going to talk about copyrights and trademarks. They don't really apply here. You could only get a copyright on certain things that are actually listed by statute. Entire animals or revived species do not appear to be one of them. And trademarks only protect the use of a word or a brand name or service mark in selling something. They don't protect the thing itself. And thus, while I may be able to use a trademark to prevent someone from selling passenger pigeon trademark passenger pigeons, I can't actually use trademarks to stop someone from selling the pigeons themselves. But there are, of course, patents. And there are some non-traditional forms of IP that I'm going to be talking about, things that are not typically considered by scholars to be intellectual property avenues, but because they deal with exclusivity, operate in a kind of a pseudo-IP fashion. And so I've listed these very broadly, and there's certainly overlap between them. There are kennel clubs, there's cattlemen's associations, and there's species preservation societies. So why don't we talk about patents? So first and foremost, I want to emphasize what patents are. Patents are the right to exclude something from doing something. They are not the right to practice the invention itself. You had that right whether you got a patent or not. And if you want to enforce a patent, the only way to do that is simply by going to court and suing somebody when you think that they have copied your invention. nobody is responsible for policing the use of the invention besides you, the patent holder. So patents consist of a number of claims, as in, and I'm making up a claim here, I claim a man-made bird whose somatic genomic DNA sequence is about 98% identical to the archetypal passenger pigeon sequence listed in reference sequence 1. That is how patents are typically worded. So which is disclosed in the patent. So these claims come in a few varieties. So typically there's composition claims which are directed to things themselves, like a chair or an actual passenger pigeon. And then there are claims on methods as well, that is the methods of going back and bringing, that is the methods of doing something, for example, the methods of de-extincting a particular species. And if we think about Dolly the sheep as an example for cloning, this is in fact what happened here. The researchers at the Roslin Institute got a composition patent on some of the cells that they use to bring Dolly the sheep back. That is certainly an avenue that researchers exploring de-extinction could do here as well. And it's my opinion that these method patents are likely to play a critical role, indeed probably the single most important intellectual property role in de-extinction projects. I say this because it has already happened. So Robert Lanza and Advanced Cell Technologies, way back in 2001, applied for patents for claiming methods of cloning extinct species, as you can see here. As many people in this room know, Rob Lanza and George Church, who's at Harvard, are collaborating on a new company called Ark Corp, which is a biblical reference to Noah's Ark, to commercialize extinct species. And so patents or patent applications like these are often the only way to commercialize these huge undertakings where the payoffs will not be for many years later. I say this, not to demonize this procedure whatsoever. Frankly, I'm personally much happier having Robert have his hands in this technology than many other scientists, but simply to demonstrate that patents not just will, but are, in fact, playing an important role in the technologies surrounding de-extinction efforts right now. All right, so those are method patents. What about patenting the animal itself? And does it matter that it once existed in nature? So the answer to these questions is maybe. So one can certainly patent whole animals. Jackson Labs, for example, sells genetically modified mice, many of which are patented. They're transgenic, so you could certainly get a patent on them. And I think the important thing to note here is that since, Beth talked about this a little bit, it's a virtual guarantee that if we bring any species back, they're going to be genetically dissimilar to their ancestors. Perhaps less so if we engaged in cloning rather than some of the kind of genome editing processes that we're going to use. And by virtue of that genomic difference, I think it's almost certainly the case that these revived species could be patented whole. Does it matter that they once existed in nature? Does it matter whether they're genetically identical or not? And the answer, again, is maybe. So in patent law, there's something known as the doctrine of lost arts. That is, if a previous invention has been completely lost to the public and another inventor is somehow able to recreate it, that the inventor is entitled to a patent nonetheless. So the cases discussing this come from the 19th century from the Supreme Court. They almost exclusively revolve around fireproof safes, which kept getting lost to the public, I suspect because they were not, in fact, fireproof. And so in theory, one could use this doctrine of revived arts to say, well, even if we are going to use cloning, we should be able to patent the extinct species itself because these technologies, quote, the animals, have been lost to the public entirely. Let me note, this exact argument that we should be able to patent recently revived species because of the doctrine of lost arts was advanced by Mark Rohrbaugh, who was the former director of the National Institute of Health's Tech Transfer Office. So this kind of thinking comes with good company. So those are the traditional forms of intellectual property. I think there's a couple of things that people don't traditionally consider to be intellectual property, but I think operate in kind of a pseudo-IP fashion. So scholars would call these the dark spaces of intellectual property, just perhaps, I guess, for historical reasons. And so I think the first and most saliently are kennel clubs. So kennel clubs have a number of functions. They often maintain a registry of breeds or species. They develop standards for those breeds. And upon application, they're able to certify whether a particular specimen comes under that breed definition. They also, as in the case of the American Kennel Club, put on pageants and whatnot as fundraising efforts. So much of the de-extinction work is complicated by the fact that we don't know how to define a particular species. This is especially problematic in the backbreeding context. How do we know when we're done? A kennel club, like society, could help these efforts by delineating these boundaries, and importantly, to protect a particular lineage of any recently revived species by preventing others from claiming that they too have a exemplar of that species as well. So if we're speaking in the purebred context, that would certainly need to be the case, that we need to have a single descendant to bring these species back. And if you are the first person to bring that species back and register it with a particular kennel club, that person who wants to copy you would almost certainly need your permission in that case. The second example, I think, are cattlemen's associations, which are relatively similar to kennel clubs. Like kennel clubs, they operate by setting standards for breed definitions, but they have a number of functions as well. They also serve as middlemen in licensing. They serve as middlemen in licensing out species. This is an example of the Holstein Association. What they do is they license out cows to be sired. They conduct their own genetic testing, and in many instances, they keep an active directory of every single member. That is here, every single Holstein cow in the United States, which I find to be somewhat incredible, using those RFID ear tags that you see up there. The Holstein Association recognizes himself as a clearinghouse, much more so than just a standard-setting organization. So for recently revived species, this may be the best way to commercialize them for private reintroduction, while at the same time keeping tight tabs on them. For larger species, let's say like woolly mammoths, that will be relatively easy. We'll know when a mammoth escapes our pen. For things like passenger pigeons, that may be entirely difficult. The last group are conservation or preservation societies. The one here is the Animal Livestock Breeds Conservancy. So they're a nonprofit that's dedicated to maintaining certain breeds from dying out from non-use. So they ensure the continued lineage of certain breeds, like the critically endangered Russian Orloff chicken, from extinction. And they may, as in the case of many plant conservancies, be responsible themselves for the continued lineage of a particular species once it's brought back, or in the case here, to certify member organizations dedicated to preserving certain breeds. So I think it's time now to answer some questions, but I just want to conclude briefly by just simply recapping what I've said earlier, because I think some of the higher order questions play an important role. And I think notably, we need to answer the question as to why we're doing this work in the first place. If we're doing it for commercial purposes, if the investment that we're putting in to bring these species back is an investment that we want to recoup, then I do think intellectual property is important, and I do think it's important to figure out which is the best method to allow that to happen. But at the same time, if we're just doing it for pure scientific research, if we want to bring the species back because we want the glory of being the first, or if we simply want to see them walk the earth again, then I think intellectual property in that case is in fact less important. So thank you very much.
So we have now a fair amount of time for questions from the audience. I'll take the moderator's privilege with first. Actually, why don't you go ahead?
This is Beth Weiss with USA Today. So I just had the question about IP. Does anything exist for biological IP law like Creative Commons? Would there be any way to use that kind of a framework for this?
Yeah, so there are a number of things that people could do to let's call it defensively protect some of the recently revived species if they want to. The first method is they can obtain a patent defensively. In other words, they can file a patent and obtain a patent and then say, I'm going to just give it away for free or license it to everyone for extremely cheaply. The other way simply is just to publish as much work as you possibly can, or to go about the process of actually reviving species and putting them here on Earth, and then waiting the statutory period, which I think under the current patent statute is 1 year. At that point, they're no longer new and nobody else can patent them. So, that's kind of a high-order strategy to be able to do that, but to the extent that people want to ensure that, in fact, these species are not protected by intellectual property, those, I think, are the two most salient methods to do so.
Hilary, go ahead. Oh, no. Okay. All right. So my question actually has to do, I think, at the intersection of the liability and property questions that I was curious to get your thoughts on both Dan and Jake. So we know that for reintroduced rare species, endangered species, at least in the United States, that liability doesn't attach if they're reintroduced within their native habitat. The idea being that they're considered fere naturae, and if liability to other property, real property owners. That if that wild animal then comes onto your property and wreaks havoc on your property, because it's considered part of your baseline property rights, they're fere naturae, natural to the baseline of the property ownership. That there wouldn't be a liability that attaches to such a reintroduction. How would that sort of analysis apply in the context of a revived and reintroduced animal?
Interesting question. So yeah, there's, I think I saw a 1537 case dealing with rabbits that made that point. So it's not that the rabbits were wild and therefore the fact that you were encouraging them on your property didn't make you liable. I don't think we know how that would apply, and I think we'd have some of the same problems you were talking about earlier about trying to figure out the baseline. That is, I think even though some animal may have been common in the region in the inter-ice age period, I think is probably not going to be enough to make that part of your baseline. If it's recently extinct, I think that may well be different. How far back you go, I don't know. I mean, it's the same sort of problem you have with, say, horses, right, in North America. Are they indigenous or not? Given the fact that they originated in the New World, became extinct here, and then came back again from Europe. So I don't think, I think if it was fairly recent extinction, I think I'd be pretty comfortable in thinking that that rule would apply, but the farther back you go, I think the more worried I'd be.
Jay? I mean, I guess what raised the question for me was when you were talking about that it's pretty clearly that these would be patentable and privately owned, because this wouldn't be the same as what was previously there. So if that's the case, I guess it's getting out, it's fere naturae, that means it's publicly owned. It's part of the public trust. If it's privately owned, then maybe that removes it from the sphere, because you're saying it's so different and unique. It's impossible for it to have been part of the historic baseline. But any thoughts? No?
Yeah, I mean, I think so. There's kind of two things to think about. The first thing to think about, and I think it's hard for non-patent lawyers to appreciate, but it all depends on how these patents are written. And so to the extent that the claims are written extremely broadly, they're going to end up protecting, and that is putting in private hands a lot of the things that maybe normatively we would like to have in the public domain, and it's kind of up to patent agents and patent examiners and inventors and the courts to figure out what the precise limits of those patent claims are going to be. The second is there's this other doctrine in patent law called prior use rights. And that is, if I can show that I've been continuously using something prior to the point where someone patented it, in theory, at the very least, I could defeat that person's attempt to prevent me from continuing to use that or not. Now, I say this in theory because while it's a doctrine that's on the books and that defendants, especially in the pharmaceutical context, or better, I should say, in the pharmaceutics context, like to plead a lot, it generally is a stinker. There's just a number of kind of exceptions to the exceptions, if you will, and courts, especially the Court of Appeals for the Federal Circuit, don't take prior use rights that seriously. That being said, when facts change on the ground, sometimes these novel legal theories tend to get a boost of confidence from the courts. I think maybe the best example is gene patenting, which for 35 years everybody thought was completely okay and permissible, and kind of only when the rubber hit the road in terms of patients having an outcry over some of the restrictive uses and licensing practices of these patents is it's something that the Supreme Court decided to take up recently and take another look at. And so maybe de-extinction is, again, one of these efforts where if someone decides to very restrictively patent a revived species, that prior use rights would be something that people who would want to prevent that could use as a defense, and maybe that would get some more traction because, in fact, it's such a novel fact pattern.
Yeah, I wanted to add one caveat, too. Given that, in reality, the reintroduced species is probably not going to be genetically identical to the original one, I think you might have, an argument that is distinct. That's like hatchery salmon or something like that. That even if you release it, might not be subject to the same rules.
Yeah, so I just had what is probably a basic question by a non-lawyer about liability issues. And that is, it's about the unknown unknowns. So it seems to me that de-extinction is one of those activities that if one were to engage in it, one would have to be able to foresee that unforeseeable bad things might happen. And that at that point it becomes unclear to me, on what level of generality something has to count as unforeseen, right? So if I, for instance, decided to, in some way, cause the Earth to be invaded by hostile aliens, right? I would be able to foresee that terrible things would happen, but not which, right?
Known unknown
So
unknowns.
Say what?
Known unknown unknowns.
Right.
Yeah, known unknown. So the question is, if you're doing something like de-extinction that involves known unknown unknowns, or foreseeable unforeseeable disasters.
Right. So let me address that in a couple different ways. First, the level of generality issue is certainly real, right? And it's discussed by the Restatement. The way we deal with a lot of really hard issues in tort law is we leave them to the jury. So a lot of the level of generality issue gets handled that way, except at extremes. I think that normally we don't impose liability for unknown unknowns, and the reason for that is, I think fundamentally, that anytime you do anything unfamiliar or innovative, there's that risk, and we don't want to tell anybody who does something new that, oh, by the way, if something completely unforeseeable happens, you're on the hook, because we don't want to chill innovation. Now, but the final thing I want to say is you have to remember in tort law we're always judging things after the fact. And so we always have this risk that we will, even though we're supposed to be talking about what was foreseeable, what was a risk at the time of the activity, but it's always a temptation, now that we know how it turned out, to to attribute that in hindsight. And so that's always a risk, I think, that something which right now we would say was quite unforeseeable, but after the fact people will say, you should have foreseen that. Some blogger somewhere in the world said that this would cause aliens to invade from, Alpha Centauri, and yeah, right, and so you should have been on notice. So that's always a risk, and I think it comes back a little bit to the social benefit thing too. If this looks like just sort of a lark that people are just doing kind of because they think they would be cool and not for any other reason, and it really turns out badly, I think that the liability risks, just as a practical matter, are going to be a lot bigger than if this is being done, for some reason, whatever it might be, that just looks a little bit more, more solid. And it's not clear, depending on which restatement you use and so forth, whether that's part of the test. But I think it's inevitably going to be something that will affect juries and judges. You were doing this and it was just for fun, and look how many people you killed. Don't tell us you couldn't foresee that.
I have a question for Matthew. I thought your discussion of the animal welfare stuff was very important, and I agree with the importance of that. But I've got a question from the animal rights perspective. Do you see any any value, any plus? Is there anything positive from an animal rights perspective about bringing back a species that used to exist, that doesn't exist, and particularly if it's the case that it doesn't exist because we shot it?
Yeah, I mean, I think it might have been a little uncharitable to say that it's unjustifiable under a rights framework. We always have competing rights claims, and how we resolve those is a question for philosophers and how we prioritize the competing rights. And certainly one can make the argument that the extinct species have a right to exist. They had a right to exist, and we took it away. And now we are ethically obligated to provide that again. My understanding of the science makes me sort of skeptical that the obligation owed to the animals we eliminated is in some way redressed by creating perfect replicas of them, or even approximate replicas of them, or by cloning them. I mean, my understanding of the cloning technology is that there's still mitochondrial DNA, and so even with cloned species, you still have something of a hybrid. So I'm not sure that, I think we can say that we had ethical obligations to the species we eliminated. That's an ethical wrong. I'm not convinced that it's redressed by what's currently going under the banner of de-extinction, although I think hypothetically, if we were actually reviving extinct species, they could have a competing rights claim against, say, the surrogate or the suffering of the individual. But if rights are framed as sort of trumps that adhere at the individual level, I think it's hard to see what's currently being called de-extinction as ethically justifiable from the rights perspective. And there are other, if one rejects that animals have individual rights, you could justify it under the other frameworks I mentioned.
And I guess then, the tougher question, individual animals might have rights. Those individual animals are dead. We're not bringing back the individual animals. Is it conceivable within a rights perspective that species have rights?
I think it is. And this is not a problem unique to the animal welfare or animal rights context. Certainly there are questions about whether there are rights that inhere in various sovereign entities, tribes, or cultures, or so on. And so
corporations.
Corporations. And my view is that ethical obligations exceed the individual. I think there are ways in which that's incompatible with the rights framework, but if we conceptualize rights outside of the individual, I do think it's possible to talk about species rights, even if we think that that it might not be entirely relevant to the question of how to treat an individual.
My question goes mainly towards the liability. You spoke about animals and the specific restatement that talks about wild animals, and there's other tort liability for domesticated animals. But what would the tort liability be for plants or fungus and things like that? And this might go more into patent, and because there's a lot of genetically modified plants out there right now that are heavily regulated that have foreseen effects that may be liable for it. So I just wanted to get some perspective on what the approach would be towards a non-animal plant and the liability that would attach to that.
So as far as I know, there's no special rule for plants the way there is for wild animals. It's just not something that came up early enough and often enough. So I think you'd be under kind of standard tort law. So you'd have this question of whether I was talking about whether creating or releasing the plant is an abnormally dangerous activity because it's likely to create such a serious risk of harm. I think for plants you also very much could have nuisance claims, and that has come up with GMOs. For example, the organic farmers whose crops may no longer qualify as organic because they're getting pollen from GMOs. In some ways, I kind of suspect that the potential impacts of reviving some kinds of plants might be harder to control than from animals, let alone if we start reviving like extinct fungi or something like that. I don't know how that plays out. So I don't think it poses unique problems, but because of the way plants reproduce, it may actually be more difficult to control the process than for animals. But I would look at GMOs, I think, as the base. And I think a lot of the problems we're dealing with here are very similar to the problems with GMOs. These are just massively genetically modified organisms in some ways, assuming we can't assuming we don't find a live egg and a live sperm out there somewhere.
I think it's important to keep in mind the sort of the invasive species laws obviously serve as another frame for thinking about
Right.
how that plants, and certainly a lot of pest control laws apply there. But we're out of time, so concludes the legal portion of our day.
Illegal portion is next.
Yeah. But actually, next is lunch, and then after lunch, we will be talking about conservation biology and ecological perspectives, as well as then talking about some of the ethical stuff. But please join me in thanking our panelists.